A woman in Texas filed her green card application 3 weeks ago. She left out one document. Nothing malicious, just an oversight. The kind of thing that happens when you're filling out a stack of federal forms alone at your kitchen table. Under the old process, USCIS would have sent her a letter asking for that missing document, giving her time to fix it. Under the new policy that took effect August 5, 2026, that letter might never come. Her case could simply be denied. If you have any immigration application pending right now, or you're about to file one, this is the update you need to understand before you submit anything else. On August 5, 2026, USCIS changed one of the most important procedural protections in the entire system, and most applicants have no idea it happened. In this video, I'm breaking down exactly what changed, who it affects, and the specific mistakes that could now get an entire case denied instead of just delayed. Let's start with what actually happened, because the headlines have made this sound bigger and vaguer than the actual policy text. On August 5, 2026, USCIS issued a policy alert updating its official policy manual. The update gives officers full discretion to deny an immigration benefit request without first issuing what's called a request for evidence, or RFE, or a notice of intent to deny, known as a NOID. Here's what that actually means in plain terms. Before this update, if your application was missing a document, or an officer had doubts about whether you qualified, standard guidance told them to send you a letter first, the RFE, or NOID, giving you a window to submit more evidence before a final decision was made. That safety net was never guaranteed by law, but it was the expected practice for years. As of August 5, 2026, USCIS has rescinded that expectation. If required initial evidence is missing, or if what you submitted doesn't clearly establish that you qualify, an officer can now deny the case immediately, with no follow-up letter and no second chance. Here's the detail almost nobody explains clearly, and it matters more than the panic headlines suggest. This discretion isn't new. USCIS has technically always had the authority to deny incomplete filings without an RFE. That authority comes from existing regulations, not from this policy update. What changed is the guidance officers were following. A 2021 policy under the previous administration directed officers to generally issue an RFE or NOID before denying incomplete cases. This update rescinds that 2021 guidance and reinstates an approach similar to a 2018 policy from Trump's first term. In other words, the rulebook officers used just went back to a stricter version. The underlying law didn't move, but how it's applied just did, immediately, for every case filed or still pending on or after August 5th. Now here's the part that surprises people who assume this only affects new filings. This applies to pending cases too, not just applications submitted after August 5th. If you filed months ago and your case is still sitting in the system, it's now subject to this same standard. That means a case that would have received an RFE under the old approach could, right now, be reviewed and denied under the new one instead. There's a second change buried inside this same update that deserves just as much attention. Timing. Previously, when USCIS did send an RFE, applicants generally had up to the full 12-week maximum to respond. Officers now have discretion to set a shorter deadline, case by case. 12 weeks is now a ceiling, not a guarantee. And if you're mailing a response from outside the United States, the extra time you used to get, 14 additional days, has been cut down to just 3 days, the same as any domestic mailed response. If your response to an RFE or NOID is only partial, USCIS will treat that partial response as a request to decide the case on the record as it stands, missing pieces and all. There's no assumption that you'll get to complete it later. If you're finding this useful, go ahead and subscribe, because USCIS has made several procedural changes like this in recent months, and we're tracking every one of them as they happen. Let's clear up the myths already circulating about this update, because there are several, and getting them wrong could cost someone their case. Myth number 1. This is a brand new law that Congress or a court created. Reality? It isn't. This is a policy manual update, an internal guidance change directing how officers use authority they already had under existing regulation. No new law was passed. Myth number 2. Every incomplete application will now be denied automatically. Reality: officers still retain discretion to issue an RFE when they consider it appropriate. This isn't a rule that eliminates RFEs entirely. It removes the expectation that one will always come first. Myth number 3. This only affects new applications filed from now on. Reality: as we covered, it explicitly applies to cases already pending, not just new filings. Myth number 4. This is only about fraud or clearly fake applications. Reality: the trigger is missing initial evidence or a filing that doesn't establish eligibility, which can happen to a completely honest applicant who simply misunderstood a form instruction or left out one required document. Myth number 5. There's nothing you can do about a case that's already filed and incomplete. Reality: you can still act. If you realize your filing is missing something, consult an immigration attorney immediately about whether a supplemental filing or amendment makes sense before USCIS reaches a decision on your case. So, what should you actually do with this information right now? First, if you have anything pending, review exactly what evidence USCIS requires for your specific form. The form instructions list required initial evidence in detail, and USCIS has said explicitly that this information is meant to be complete. Second, if you're preparing a new filing, treat it as your only opportunity to get it right. Don't submit a placeholder or a mostly complete application, assuming you'll get a chance to fill in the gaps later. Third, if you do receive an RFE or NOID, respond as completely as possible, and don't assume you have the full response window. Check the deadline stated on your specific notice. Fourth, if you're mailing anything from outside the United States, build in extra time, since the mailing allowance has been cut significantly. Fifth, if your case is complex or you're unsure whether your existing filing meets the initial evidence standard, this is a good moment to have an immigration attorney review it before USCIS does. Employers sponsoring workers should pay close attention here too, because this doesn't only affect individual applicants. A petition filed on behalf of an employee, an H-1B, an L-1, an immigrant petition tied to a job offer, can be denied under this same standard if the supporting evidence package is incomplete when filed. That means HR teams and company immigration counsel now carry the same "file it complete the first time" responsibility that individual applicants do. A missing wage determination, an incomplete job description, or a support letter that doesn't fully establish the position's requirements can now result in a denial rather than a chance to supplement the record. If your immigration status depends on an employer-filed petition, it's worth directly asking whether the filing was reviewed for completeness against the current form instructions before it went in. Let's cover the mistakes people are already making with this news. Mistake 1. Assuming this doesn't apply to them because their case was filed months ago. It does apply, if the case is still pending. Mistake 2. Treating this as reason to panic and rush a new filing without double-checking every required document. Rushing under fear tends to create exactly the kind of incomplete filing this policy is designed to catch. Mistake 3. Assuming an RFE, if one does arrive, comes with the old 12-week timeline automatically. Check the actual deadline on the notice itself. Mistake 4. Sending an incomplete response to an RFE and assuming USCIS will follow up again. Under this policy, a partial response may simply be decided on the record as submitted. Mistake 5. Not reading the specific form instructions for your exact benefit type, and assuming general immigration knowledge from a forum or a friend's case covers what your specific form requires. Here's the honest summary. On August 5, 2026, USCIS restored officers full discretion to deny immigration benefit requests without first sending an RFE or NOID when required evidence is missing or eligibility isn't clearly established. This applies to pending and new filings alike, and it comes paired with shorter response windows for any RFE or NOID that is issued. The underlying law didn't change. The practical margin for error did. Think back to the woman in Texas from the start of this video. Under the old approach, that one missing document would have triggered a letter, a chance to fix it, and a case that stayed alive while she gathered what was needed. Under the policy that took effect August 5, 2026, that same missing document could end her case outright, with nothing but a denial notice in the mail. Nothing about her eligibility changed. What changed is how much room the system now gives her to be human about paperwork. For anyone with a case in the system right now, the message is the same. File as if there's no second chance, because as of this month, there might not be one. This video is for general information only and does not constitute legal advice. USCIS is accepting public comments on this policy until September 7, 2026, and further guidance may follow. Every case involves details specific to that applicant, so consult a licensed immigration attorney before making decisions based on your individual situation. Follow for more updates like this one, and subscribe to the channel so you don't miss what's coming.